Hello, and welcome to another episode of the Lexbe webinar series, your destination for sharp, timely, and practical guidance on eDiscovery, generative AI, and digital forensics. I'm Jeff Fugit, Chief Revenue Officer here at Lexbe, and I'll be your host for today's session. There are a few areas of litigation evolving as quickly as eDiscovery, and over the past couple of years, that pace has only accelerated. Remote work, collaboration platforms, mobile data, cloud systems, and increasingly complex file types have dramatically expanded both the volume and the variety of electronically stored information that legal teams are expected to manage. At the same time, generative AI has entered the conversation. While there's a lot of excitement around it, there's also a lot of uncertainty. The real question for most litigation teams isn't whether GenAI will impact eDiscovery, because it already has, but how to use it responsibly, defensibly, and in a way that actually improves outcomes without introducing risk. And that's what today's session is about. In this webinar, we're going to walk you through how GenAI can help you comply with federal and state rules for document productions. The goal is to leverage GenAI to efficiently and accurately generate production document category assignments for RFP compliance while keeping you in complete control of the process. This is a practical, educational session, and our aim is for you to walk away with a clear framework you can apply immediately in your own matters. Before we get started, we've got a few quick housekeeping items. Our webinars take place monthly and cover leading-edge issues in eDiscovery, generative AI, and digital forensics. If you experience any technical issues, don't stress. Just shoot us a note at webinars@lexbe.com and we'll jump in to address those right away. We'll be sharing a recorded version, a slide deck, as well as a podcast version of today's session shortly after the event. So keep an eye out on lexbe.com and our YouTube channel. And yes, we want your questions. Drop them into the Q&A panel, and we'll get to those at the end of today's presentation. Also, at the end of today's session, we're going to ask for your help. Please complete the survey at the end of today's session so we can continuously improve our eDiscovery webinar series and deliver the topics that are most relevant to you and your practice. And before I turn it over to our guest speaker today, just a quick intro to Lexbe in case you're new to us. Lexbe has spent over 19 years helping legal teams win document-intensive litigation, and we do that with the most advanced GenAI deployment in eDiscovery. Lexbe Pilot is a GenAI-powered full-case analytics and query tool that outperforms legacy early case assessment technologies. You can ask Lexbe Pilot any question that you have about the case or documents in the case. It also delivers a strategic case insights report at the click of a button. Lexbe Autopilot, which is GenAI-powered automated document review for responsiveness and privilege. It has outstanding precision and recall scores and is a fraction of the cost of traditional managed review. It works great for third-party subpoenas and document-intensive matters. Lexbe Copilot, your GenAI-powered assistant for your inline document review, included in every Lexbe plan at no additional cost. The use cases are only limited by your imagination. If you have an acronym-intensive document, Lexbe Copilot will define the acronyms for you on the fly. If you need to summarize lengthy medical records, Copilot does a great job. It's great for summarizing depositions as well. Do you need to analyze financial statements and transactions and track money flow? Lexbe Copilot will provide you with a comprehensive delimited report on the money movement. Do you need to compare two contracts and determine which one is more favorable for the buyer or the seller? Again, Lexbe Copilot will provide you with a comprehensive analysis, and it can do a lot more. In the past 2 months, we've had exponential growth in customers adopting Lexbe Copilot and Pilot that are both included in Lexbe subscription plans at no additional cost. Lexbe is also lightning fast, powered by over 10,000 CPUs, and able to process over 1 million documents an hour. Lexbe gets you from document ingestion to review faster. One recent client uploaded 1.64 terabytes of PSTs, and they were reviewing those emails the same day. We have an intuitive, ROI-friendly interface. We also have a full-service forensic lab staffed with Cellebrite and Magnet Axiom certified forensic investigators. We perform remote or on-site forensic collections That includes smartphones, cloud accounts, social media, whatever you need. We can help you acquire the evidence for your matter. If you'd like a demo or a complimentary forensic consultation, simply email us at sales@lexbe.com, and we'd love to show you how Lexbe can support your next case. And with that, it's my pleasure to introduce today's speaker, Gene Albert. Gene is the CEO and co-founder of Lexbe. He is a former litigator and an expert in eDiscovery. He is a sought-after speaker on eDiscovery and legal tech topics. Gene has a JD from SMU, and he has an MBA and BA from the University of Texas. So without further ado, I'll turn it over to Gene Albert. Gene?
Hello, I'm Gene Albert, CEO of Lexbe. Welcome to this edition of the Lexbe eDiscovery webinar series. I'll be speaking today about using GenAI for production document correlations under Federal Rule of Civil Procedure 34B2E, a new, affordable, and fast approach for handling RFP issue assignments in document-intensive cases. Large litigation productions continue to stress existing review workflows and procedures as document size and complexity has grown under the weight of our increasing dependence on electronic communications. The rule structure of the Federal Rules of Civil Procedure in many states allow for a theoretical choice regarding how to produce documents and other electronically stored information. The first choice is to produce the documents and other ESI as ordinarily maintained by the producing party in the usual course of business. The second choice is to produce in a manner corresponding with categories from the request for production. How either of these two should be applied in the context of modern large commercial disputes is unclear. A majority of courts hold that modern ESI-based productions do not strictly meet the usual course of business requirements. In this event, category attribution or correspondence would be required, although courts can be flexible in how it's implemented. The rationale is to meet the letter of the Federal Rules of Civil Procedure and does provide the requesting party with the means of focusing review on large productions and not being overwhelmed. Other courts do not read the Rule 34 requirements as literally and instead allow modern ESI productions without request for production category correspondence or labeling, so long as there's sufficient document metadata provided in usable format in a production load file. The counter rationale here is that modern eDiscovery review software used by most sophisticated firms allows for effective review of production, so long as the production includes the applicable load file information and corresponding relevant metadata. This may be the situation as well if the parties have an ESI protocol or court order that supersedes the default language in Rule 34. Before the arrival of GenAI automated coding options that became available recently, there were a few good options for a producing party in a document-intensive case where category correspondence was required. The cost could be substantial and out of proportion with the expected benefit to the receiving party. But courts do recognize that associating produced documents with the specific categories is valuable for efficient litigation and should be encouraged or required when applicable. In this webinar, I'll discuss Rule 34's requirements, interpretations, workflow approaches to coding this information if and when it's required, and new modern cost-effective alternatives when GenAI automated coding is available. This controversial technology holds the promise of making categorical assignments relatively automated and accurately, as well as other helpful applications of artificial intelligence to the eDiscovery processes generally. We'll start with discussing production attribution and correlation requirements under federal and state law. In pertinent part, Rule 34 of the Federal Rules of Civil Procedure B2E provides that unless otherwise stipulated or ordered by the court, these procedures apply to producing documents or electronically stored information. A party must produce documents as they are kept in the usual course of business, or 2, must organize and label them to correspond to the categories in the request. The commentary to the rule notes that this requirement is intended to protect against deliberate or inadvertent production in ways that raises unnecessary obstacles for the requesting party. So the rule provides that the producing party has the option of producing documents in the usual course of business or organized and labeled by RFP category, sometimes known as document correlation. The parties, of course, can always stipulate a production with other requirements or have an ESI order that overrides these requirements. Many states have similar or identical requirements. A couple examples. First, California Code of Civil Procedure Section 2031.280A provides that documents shall be produced as they are kept in the ordinary course of business or organized and labeled to correspond with the categories of the demand. And similarly, in New York, Civil Procedure Law Rule 3122C provides that whenever a person is required pursuant to such notice or order to produce documents for inspection, that person shall produce them as they are kept in the regular course of business or shall organize and label them to correspond to the categories in the request. For the remainder of this talk, I'll reference the federal rule version of this requirement. The majority interpretation of this issue has been to require document correlations in complex ESI productions in which the producing party cannot sustain that the production was made as documents were maintained in the ordinary course of business. The strictness in how ordinary course of business is interpreted varies, and it can be argued that anything that approaches the process used in collecting ESI for eDiscovery processing and review fails as standard, written in the days of paper files, folders, and Redwells. Other courts attempt to apply the language more liberally to allow the spirit of this provision to apply. A recent example from last year is Sievert Electric Service versus Stracco. The Illinois District Court here noted that the majority view is that Rule 34B2EI disjunctive organization requirements exists alongside Rule 34B2E2I's separate ESI formatting requirement and applies to both ESI and hard copy documents. But some courts have held that the organizational requirement of the rule does not apply to ESI productions, and a roadmap is not required under Rule 34. The court also noted that the advisory committee's note to the 2006 amendment regarding ESI productions generally should be subject to comparable requirements to protect against deliberate or inadvertent production in ways that raise unnecessary obstacles for the requesting party. The court added as an additional rationale that without a clear connection between the eDiscovery, the discovery request and the corresponding eDiscovery responses, the discovery responses can't be deemed reliable and used as efficaciously as they otherwise could. Next, we'll discuss the minority approach, which is more flexible. As noted by the Sievert Court, other courts have adopted the minority view that productions usably formatted with electronically stored information and properly formatted load files do not require this level of organization due to their inherent searchability and other functionality. A recent example is Municorp versus Wilson, also a 2025 case from the District of Maryland. The court held that it will not compel ESI categorization in this circumstance where the ESI production is searchable, the production includes required metadata, and the producing party identified the relevant custodian of the ESI. The court emphasized usability over formality, noting that all courts focus on usability of ESI, with the minority finding that searchable ESI is inherently usable and the majority placing an extra layer of protection on that usability by requiring compliance with the organizational requirements of Rule 34B2EI. In commentary in a 2025 blog, Michael Berman made the practical supporting point that if ESI is produced with appropriate metadata, the receiving party will have the information and ability to determine how the documents were kept in the ordinary course of business by sorting on custodian, folder, file path, sender, recipient, or dates. And I'd add to that it's a usual practice to capture, as far as eDiscovery collection, the complete file path of how the data was maintained in the system, and this allows for a reconstruction of what the specific folder file paths were in any documents kept in electronic format. So in sum, there's a split in authorities as to whether documents and other electronically stored information in complex productions should require category attributions, or if metadata with a properly formatted load file as provided with modern eDiscovery platforms is sufficient alone. Next, we'll discuss workflow trends and developments applicable to the issue of document RFP categorizations, starting with the use of contract managed review companies. A contemporary trend over the last couple of decades has been the growth of contractual managed document review. Previously, document reviews, large and small, were done by law firm staff or sometimes temporary contract attorneys hired from a general staffing company. As the size of document reviews scaled with electronic document production, a new type of service provider known as a managed document review company emerged. While staffing firms had placed temporary contract attorneys in law firms for years, these new managed review firms delivered a managed review service, often priced on a per document basis or budgeted to that. This increased speed and predictability of large document reviews that exceeded the internal capacities of the law firms handling the case. Managed review providers operate under a customized review protocol for each project, usually including tagging documents for responsive relevancy, privilege, hot docs, and particular identified case issues. Managed review firms will run also sophisticated QC protocols, including second-level quality control review. As technology-assisted review algorithms were developed, which are discussed below, managed review companies often integrated and managed the automated responsiveness review approach of a hybrid workflow with automated and managed human review outsourced service combined. With respect to Rule 34 document issue coding, managed review protocols can and often do include this document tagging as part of projects. Arguably, doing the document correlations as required by Rule 34 in state law can be completed as an incremental part of a managed review project, and this perhaps has encouraged courts and parties to follow the requirements of document RFP attributions more closely than they otherwise would have. Managed review of large document cases is the gold standard in that contract lawyers trained to some degree on the case specifics have many eyes on many or all of the documents. On the other hand, this is the most expensive approach to document review. Reviewers must be independently trained, and the common practice is for the producing firm to draft a detailed review protocol instructing contract reviewers in how to code documents in the matter. But we should keep in mind that the gold standards are not perfect or without error. Even trained reviewers can and do disagree on whether any particular document is responsive or not. In studies of large document reviews, agreement of multiple reviewers on responsiveness is surprisingly low. So the existence of any theoretical gold standard is more of an aspiration than an actuality. Contract managed reviews can be very expensive, running from 50 cents to several dollars per document, depending on the scope of the review, the language of the review, the location, and qualification of the reviewers, whether they're specialized or not, and other factors. With large cases potentially involving hundreds of thousands or even millions of documents, the cost of a managed review for these document-intensive cases can be substantial. In addition to the sometimes prohibitive costs, the time to manually review a large case can stress or disrupt case timelines. Another technology introduced in the last couple of decades in the legal industry is technology-assisted review, sometimes called also TAR, CalTAR, or simply predictive coding, depending on the specific technology used and provider marketing designations. TAR involves a trained discriminator algorithm utilizing sample human document coding determinations to predict binary coding or other documents in the case. It's used primarily for responsive and non-responsive, but with enough documents and training, it can work with other coding fields as well. TAR is fundamentally keyword-based, but may incorporate more sophisticated AI-type semantic analysis to some degree, but usually not to the degree that we see in the new GenAI and large language models. Traditional TAR can return documents beyond or different from what simple keyword search alone can find, and that's its value. But it can also suffer from the same shortfalls of keyword searching, including a failure of readable text, images, and other unreadable types of documents. A TAR also cannot apply the same degree of inference logic that the newer large language models do so effectively, and as a result, they may miss many documents that do not match TAR's identified weighted keywords. TAR never became highly popular with reviewing attorneys. Also, while precision and recall statistics on TAR projects have been acceptable, many attorneys have more confidence in either using keyword search alone or shifting to a human-managed review, as previously discussed. While TAR algorithms in theory could support a document correlation process as contemplated by Federal Civil Procedure 34, in practice that has not worked out well. The amount of documents and training that would be required to use this approach for document correlations on specific issues is usually makes it unhelpful. Instead, TAR algorithms have been used more for responsiveness or privilege coding decisions. Next, we'll turn and discuss the potential for using GenAI and large language models in document reviews. The release of GenAI large language models like ChatGPT from OpenAI and Claude from Anthropic have begun to be used in legal review workflows in the last year or so. The potential is substantial, and the industry is still working through how to best use this powerful technology consistent with procedural requirement and best practices in the legal industry. In our experience, GenAI models can make responsiveness relevancy determinations very accurately at comparative levels with human reviewers. Additionally, it can make the issue coding determinations as required by Federal Civil Procedure 34, as well as providing reasons for its determinations. A GenAI automated review workflow is a blending of what had previously been used in managed reviews and TAR reviews. As part of the process, a detailed prompt is prepared based on what would be generally responsive in the case. This is done after review of and consolidation of the pleadings and applicable RFPs. The responsiveness prompt is tested for accuracy by having the producing law firm review and hand code some documents as controls. The control sample would include responsive and non-responsive documents, and then use the human coding as a test for the accuracy of the GenAI prompt. After review of control sample determination, the prompt language for the GenAI prompt can then be revised as needed and tested recursively until adequate precision and recall is achieved. The number of documents that must be hand-coded as controls depends on the requirements of the case, the ESI protocols in place, and the rigorousness and formality of the QA process that will be supported. Once the prompt is prepared and tested, it is run against all the documents in the case. As this is done inside an eDiscovery platform, the documents have been unitized. In that compound, electronic files have been separated into their most specific document elements. For example, zip and other archive files are decompressed. Emails are usually ingested as compound email archives called PSTs, and these are separated into individual emails, and then the individual emails are separated with attachments recursively separated and identified with the emails. Metadata is extracted, and the constituent parts of complex nested files are properly associated with each other for database retrieval. In large document cases, this can be a massive process, as documents can be nested deep into 8 levels or more in practice. The GenAI model then returns a responsiveness attribution of responsive or not. While this is, of course, valuable in itself, the GenAI models go further and return an ordinal ranking of responsiveness, for example, from 1 to 10, with 10 being the highest ranking. This can be useful in informal QC and in ranking documents for human review. As the modern models can exhibit sophisticated inferences, we and others find the results to be superior to keyword-based TAR, while at a fraction of the cost of human contract managed reviews. Next, we'll discuss document summaries and reasons for responsiveness. The workflow and the GenAI prompt can be instructed to return a document summary as well. This can be done very accurately when the subject document is loaded into the document prompt and the summary is not relying on general training of the model, which would then be more subject to hallucination. The best practice here is to instruct the model to look only at the 4 corners of the document for its summary and to not apply any trained knowledge outside of the document or supplement a response with a web search. Additionally, the large language model can be instructed to return a textual explanation for its responsiveness determination. This is a benefit that other technologies or review methodologies either cannot or usually do not provide. Search and traditional keyword-based TAR cannot provide a reason for its determination. This could be done with a managed review, but would slow the review rate appreciably and add to the cost of the review. A review process might include reviewing the reasons for the responsive determination as part of a GenAI process as an informal QC step. Next, we'll discuss adding privilege review. Privilege can also be included in this process. GenAI can identify privilege in work product documents with high accuracy. On the one hand, using GenAI review to identify potentially privileged documents may not be as critical part of the process, as simple keyword search likely identifies most privileged documents by focusing on the lawyer's name, email, or subject matter of the discussion. On the other hand, GenAI can provide other important functionality in privilege review beyond provided by keyword searching and other technologies. One example is in large cases determining the reason for privilege or work product claim can be time-consuming, expensive, and tedious. A GenAI process could generate draft explanations for privilege logs quickly and accurately for review and finalization. Also, for cases where the risk of providing privileged documents to opposition is substantial and unacceptable, a GenAI process can be run against all the documents not otherwise identified as privileged as a backup QC step. The impressive ability of LLMs to be able to draw inferences between documents well beyond what other technologies can do, makes it a good tool as a backup check in cases where the risk of releasing privileged documents, even with a clawback in place, is unacceptable. Next, we'll discuss quality control. Quality control can be approached in different ways in a GenAI assisted automated review. On the rigorous end of the spectrum, a sufficient number of control documents may be segregated and manually coded to support a 95% statistical confidence level, depending on the case size and variability. At that point, precision and recall statistics can be generated in a manner similar to an analogous with those historically used in tar-based productions discussed above. Precision measures how many documents identified by the prompt as responsive are in fact responsive when reviewed by qualified human reviewers. It is commonly referred to as the true positive rate as well. For example, if the prompt flags 100 documents as responsive and human review confirms that 90 are truly responsive, the precision is 90%. The corresponding false positive rate is therefore 10%, 100% minus 90%. Recall, by contrast, measures how many of the truly responsive documents in the control set are successfully identified by the prompt. For example, if the control set contains 100 documents that qualified human reviewers determine are responsive and the prompt identifies only 80 of them, then the recall rate would be 80%. The analogous false negative rate is 20%, e.g. 100% minus 80%, and represents the documents that human reviewers would consider responsive, but the AI prompt fails to identify as such. Precision and recall are inherently in tension. The easiest way to achieve 100% recall with zero false negatives is to produce all documents, which would result in an extremely low precision and it would be an impermissible data dump. Conversely, producing only a single responsive document would yield 100% precision and zero false positives, but at the cost of an unacceptably low recall rate. Neither extreme or anything approaching it is defensible in practice. But the point is that attempting to over-engineer a very high precision or recall rate inevitably leads to an offsetting lower of the corresponding rate. High precision coupled with low recall indicates that the prompt is conservative and accurate but misses relevant material. High recall coupled with low precision indicates that the prompt captures most responsive documents but over-includes non-responsive ones. Iterative prompt refinement, which is referred to as prompt engineering in the AI context, seeks to balance these competing goals and objectives in light of case-specific priorities. These could include factors such as whether minimizing overproduction or avoiding missed responsive documents is more critical under the applicable standards in the matter. Where formal quality control is required, an out-of-sample validation set should be identified and withheld from prompt development to independently assess the performance of the automated GenAI review as part of statistical QC. A QC process requiring formal statistical measures is not always required or appropriate in a case, and an informal QC process may be acceptable and optimal. Formal QC procedures were introduced with TAR processes discussed previously, but we should not assume these are required in all productions. Nothing in the Federal Rules of Civil Procedure explicitly requires them. They are not used in a vast majority of document reviews in productions that rely on internal law firm attorney manual review or keyword search alone, even though theoretically and conceivably they could be applied there beneficially as well. If a more informal QC process is used, then the ability of GenAI models to return ordinal rankings on a 1 to 10 scale can be used to confirm with a manual review of the selected documents at each level that the prompt is doing what it's designed to do. The documents at the margin of what's responsive, for example, maybe an 8 and above on a 1 to 10 scale, can be reviewed in greater detail as part of a quality control process. Another approach is to use the ordinal rankings of the GenAI first pass codings to rank documents for the law firm human review as a second pass. This approach allows for attorneys' eyes on confirmatory review of all documents and would not require a formal QC process. The group ordinal responsiveness allows for high responsiveness documents to be grouped and reviewed together. The ability of AI models to provide an AI-generated document summary, a reason for responsiveness, and specific issue coding allows for the human review to be completed in a fraction of the time that would be required otherwise. In particular, the reasons for responsiveness determination by the 1 to 10 level can be reviewed separately to assure that the model is operating as anticipated. Next, we'll discuss how GenAI prompts work with issue categorization specifically. If one is in a jurisdiction that requires categorical assignments to productions, the GenAI review workflow can be modified to determine categorical assignments and add that to the prompt return. Of course, the entire process does not need to be used, and the elements that complete category labeling for Rule 34 could be done separately. This might be the case where responsiveness and privilege review has been completed with search alone or manual review or managed document review. Courts do not set a fixed number of production categories under Rule 34. Instead, they apply a functional reasonableness standard focused on usability and traceability rather than simple arithmetic. Categories here can be understood as substantive groupings reflected in the requests, not a one-to-one match with numbered requests for productions. Courts permit consolidation of overlapping or duplicative requests into fewer categories, so long as every request for production is accounted for and the requesting party can reasonably determine which documents were produced in response to each request without guesswork. Courts evaluate whether the categories are substantively coherent, whether all requests for productions map to at least one category, and whether the structure avoids both over-aggregation, which looks like a document dump, or over-fragmentation, which looks formalistic and burdensome. As a practical norm, litigants might use roughly 8 to 20 categories in commercial cases generally for issue attribution, and up to 20 to 40 in very large multi-issue or multi-location or custodian matters. There's no specific requirement under Rule 34 that every document be attributed to every potentially applicable category. Instead, courts ask whether the chosen coding approach preserves traceability and avoids prejudice. Any more elaborate requirement could quickly become unwieldy and burdensome. Instead, primary category attribution is generally sufficient, where a reasonable reviewer would encounter the document after reviewing the primary category. Categorical assignments with GenAI can also substantively group documents by issue for the producing firm. There may be very reason to channel certain issues to specific human reviewers with certain expertise, or documents categories to certain issues may be important for in preparation of upcoming specific depositions, etc. Next, we'll turn to an overview of the GenAI-assisted automated review workflow. This graphical workflow builds on established eDiscovery practices while integrating GenAI large language models to support responsiveness determinations, category assignments, and other review protocols in a defensible and efficient manner. The process consists of sequential but interrelated eDiscovery stages with defined decision points governing the allocation of work between AI using the large language models, search tools, and human reviewers. This shows an overall workflow including responsiveness, but also privilege review and issue category assignments under Rule 34. As previously mentioned, if the responsiveness review has already been done or is done with a non-AI based methodology, then categorical assignments can be completed as a discrete project. This is shown with the bolded boxes on the slide. The workflow begins with planning, during which the producing party defines the overall review strategy, production timeline, and the respective roles of GenAI, keyword search, and manual review. Native files are identified for collections, and decisions are made regarding custodians, repositories, and document types. At this stage, counsel also determines whether category assignments under Rule 34 B2E, privilege identification, or issue coding will be incorporated into the review protocol. During collection and culling, documents are collected in a native form and ingested into the eDiscovery platform for processing. Standard processing steps are applied, including denisting, deduplication, and filtering by date ranges and agreed upon keywords where applicable. Archive files are decompressed, combined files are separated into constituent parts, and nested documents are properly associated, resulting in unitized documents for review. Non-relevant and or out-of-scope ESI is removed to reduce volume and cost before substantive review begins. The next stage involves identification and segregation of documents for manual review. At this point, document types and review categories that require human judgment are identified. These may include non-standard or proprietary file types, document with unreliable text extraction, marginal responsiveness groups, or high-risk materials such as potential privilege or work product. Where formal quality control is required, an out-of-sample QC set may be drawn at this stage to support later validation of AI results. A GenAI prompt is then drafted and tested based on the pleadings, claims, and defenses, and a consolidated version of the outstanding request for production. The prompt is written in a lawyer-friendly language and may include criteria for responsiveness, issue identification, privilege indicators, and where applicable, production category assignments. Sample documents are manually coded by qualified reviewers and used as controls. Through iterative prompt engineering, the prompt is refined and retested to balance precision and recall in accordance with case requirements and the selected QC approach for the matter. Once validated, the workflow proceeds to AI responsiveness classification. The GenAI model is run across the document corpus to classify documents as responsive or non-responsive. In addition to binary responsive determinations, the model may assign an ordinal responsiveness score, such as 1 to 10, allowing the documents to be filtered into batches for prioritized review, targeted QC, or escalation to human reviewers. Where category assignments are required, the model can also assign a primary category to responsive documents based on prompt specifics. The workflow then incorporates other review protocols as needed. This may include identification and redaction of a PII or personally identifiable information, privilege, and work product review, confidential, and attorney's eyes only designations. GenAI can apply a consistent coding across large document sets while human reviewers focus on reviewing selected documents in batches, resolving edge cases, and validating the AI output. Finally, the process moves into quality control and production. QC measures are applied based on the agreed protocol, which may include statistical validation, review of the AI results against control sets, and targeted human review of marginal and high-risk groups. Human reviewers perform final QC to confirm responsiveness, category assignments, privilege determinations, and redactions. Documents are then produced in the required format and transmitted to the requesting party. In this section, we turn from legal theory and workflow design to concrete examples drawn from the Lexbe eDiscovery platform, our GenAI-enabled software. The first slide here illustrates a GenAI document summary produced directly from the four corners of an individual document. The GenAI model is explicitly constrained to rely only on the document text itself. It importantly does not supplement the summary with external training knowledge or web-based information. As discussed above, this constraint materially reduces the risk of hallucination. It also increases reviewer confidence in the output. In our experience, hallucination and similar error in AI output is very rare when the prompt is well written and the model programmatically is constrained to limit its interpretation and inferences to the document or the document being reviewed. Documents being reviewed, and these are within the model's context window in total. The summary serves several useful purposes. First, it provides an easy and effective way for attorneys to conduct QC spot checks or targeted review. Second, it significantly reduces review time when documents are escalated for confirmatory human review. Next, this slide shows an example of a responsiveness prompt drafted in plain legal language. The prompt is derived from the pleadings and a consolidated request for production, as discussed above. The prompt functions in much the same way as a traditional managed review protocol. However, here instead of being implemented potentially inconsistently by many human reviewers, it is applied uniformly and at scale by the GenAI model. Importantly, the prompt reflects the substantive theory of the case rather than relying on keyword lists alone. This illustrates a core distinction between traditional TAR approaches discussed above and GenAI. The GenAI large language models are instructed to evaluate contextual relevance and inferential significance, not just term frequency and proximity as the previous TAR technology did. This slide shows the AI's responsiveness output for a specific document. The return includes a binary responsiveness designation. It may also include an ordinal responsiveness score, such as a 1 to 10 ranking. As discussed above, this type of output supports both formal and informal QC approaches. Documents with high scores can be prioritized for immediate production or attorney review. Documents near the margin can be sampled for validation by human reviewers for quality control. This structure also supports proportionality. It allows counsel to focus attention where it matters most without imposing mandatory formalized statistical validation for every document. The next two slides illustrate using a GenAI prompt for issue assignment. This slide shows a separate prompt focused on issue identification rather than general responsiveness. This is relevant for a Rule 34 type category correspondence coding pass. And the next slide shows the output, and this type of workflow makes consistent attribution to categories or labels required for correlation feasible across large document sets, done very quickly and at a manageable cost. Here's an additional slide that illustrates some more about a prompt that explicitly maps issue groupings to requests for production. It also shows all the AI's corresponding response. The illustration demonstrates that RFP mappings do not need to be rigid or mechanical. Documents are associated with functional categories that reasonably correspond with the requesting party's demands in the RFP. This preserves usability for the receiving party while avoiding unnecessary fragmentation or over-engineering of categories. This slide shows a combined prompt incorporating responsiveness, issue identification, and RFP category mapping into a single instruction set. As discussed above, GenAI workflows are modular. These functions may be combined or run discretely depending on the posture of the case and prior review steps. The slide illustrates how GenAI can unify what were often historically separate review passes. This reduces both cost and elapsed time of the review. It also improves consistency across the corpus of the documents. There is a danger that if the prompt is too overloaded, the precision and recall will suffer. On the other hand, the rapidly expanding capacity of the commercial large language models has been amazing on what they can handle, and with good design, prompt engineering, and implementation, we can get very good quality results. There are many practical advantages of the one prompt approach, and its efficacy can be determined in part by as part of the prompt development stage and testing and refined as needed. This slide shows the large language model GenAI's integrated output from the combined prompt. The return includes a responsiveness determination, category assignment, a document summary, and an explanation. The explanatory text is particularly significant. As discussed, traditional search and TAR approaches generally cannot explain why a document was classified as responsive or assigned to a particular category. Here, the AI's reasoning can be reviewed directly. This supports informal QC, increases attorney confidence, and improves defensibility if production decisions are later questioned. This slide provides a fuller example of the large language model GenAI's narrative explanation. The explanation ties the document's content to the identified issues and mapped RFP categories. In practice, these explanations can be sampled and reviewed independently of the documents themselves. This provides an additional validation layer, which allows counsel to confirm that the model is applying the intended legal theory consistent with the prompt refinement and QC approach discussed above, without having to take the time to read into the review document specifically. This slide shows a privilege-focused prompt. It illustrates how privilege review can be integrated into or layered onto a GenAI workflow. As noted earlier, the value here is not limited to flagging potentially privileged documents. The model can also generate structured explanations describing the basis for privilege or work product protection. The capability can materially reduce the time and costs associated with privilege log preparation in cases where privileged communications are common and in the collected ESI and the risk of unintended release is high. It can also serve as a fallback safeguard to review documents otherwise identified as responsive and non-privileged as an additional safety check to ensure that no privileged documents aren't being included in the production. This final slide shows automated QC statistics. These formal QC metrics demonstrate how GenAI outputs can be evaluated using familiar precision and recall concepts when formal quality control validation is required. In other matters, the same information can guide targeted human attorney review and sampling. In either case, the workflow reinforces that GenAI does not eliminate human judgment. Instead, it reallocates human effort and time towards edge cases, high-risk documents, and final decision-making. Taken together, these illustrations demonstrate that GenAI-assisted review is not a conceptual abstraction. Instead, it's a practical extension of established but strained eDiscovery workflows. Responsiveness determinations, issue identification, and Rule 34 category assignments can be performed at scale with transparency and proportionality. In conclusion, modern document-intensive litigation continues to challenge traditional review workflows. This is particularly the case when courts require productions to be organized and labeled to correspond to requests for production under Federal Rules of Civil Procedure 34B2E and analogous state laws. While federal and state courts remain divided on whether complex ESI productions must include categorical correlations or as a matter of course, or whether instead metadata-rich searchable productions are sufficient, there is broad agreement that usability, traceability, and proportionality are the governing principles. The fact that review procedures can include these issue attributions and they can be helpful to the reviewing party may encourage courts to continue to require them. Historically, producing parties faced a difficult choice when category correlations were required, as the cost can be substantial in document-intensive cases. The emergence of GenAI-based automated reviews introduces a new practical alternative. GenAI models can perform responsive determinations, issue and category assignments, privilege identification, and document summarization with accuracy comparable with human reviewers, while dramatically reducing cost and timeline pressures. Category labeling can be part of an overall GenAI review workflow or done discretely as a separate project as needed. By integrating GenAI into a defensible review workflow, the producing parties can satisfy Rule 34B2E requirements in a manner that's efficient and reliable. GenAI makes this level of compliance achievable even in very large models, transforming what was once expensive and burdensome obligation into a scalable and affordable component. In short, GenAI-assisted review represents a meaningful evolution in how litigants can meet production categorization requirements and obligations under Rule 34, aligning the technology capability with procedural expectations while preserving human oversight and legal judgment. Thank you for attending.
Thanks, Gene, for those practical insights and best practices utilizing GenAI for assigning document production categories under FRCP 34B2E. Lexbe has been helping litigators win cases for more than 19 years. Jordan Howlett is a litigator who heads up a multi-office boutique firm. He often faces off against larger, well-funded opposition. With Lexbe Copilot, he quickly assembles fact-rich narratives that give him an edge in litigation. David Jones was initially concerned about getting outmatched, but Lexbe's GenAI-powered eDiscovery platform gave him and his team the upper hand and a verdict to match. Paige Tackett at Thompson Co. needed Lexbe's speed to get a production out the door. With tight deadlines looming, Lexbe's processing engine helped her go from ingestion to production in record time. As I mentioned in the introduction, at Lexbe we have a state-of-the-art digital forensics lab. We perform remote and on-site forensic collections that are fully defensible. If you have evidence that you need collected for your next case, we'd be happy to support you. At Lexbe, we've also engineered a highly advanced GenAI-powered eDiscovery platform. We have 3 primary tools that streamline and automate while keeping you in full control. We have Lexbe Pilot, which is engineered to provide you a comprehensive analysis across the entire corpus of documents in your case. It's the best early case assessment that generates a comprehensive insights report with the click of a button, including entities, timelines, key events, causation, and more. It's an incredibly powerful complement to keyword search. We have Lexbe Copilot, which is your GenAI-powered assistant for your inline document review, included in every Lexbe plan at no additional cost. Pilot's included as well. The use cases are only limited by your imagination, as I mentioned. You can summarize documents, analyze documents, define acronyms, translate languages, identify PII, PHI, and a lot more. And then we have Lexbe Autopilot, which is GenAI-powered automated document review for responsiveness and privilege. It has outstanding precision and recall and is a fraction of the cost of traditional managed review. And it's fantastic for issue coding for document production category assignments. If you'd like a demo, please reach out to us at sales@lexbe.com. That brings us to the end of today's webinar. On behalf of the entire Lexbe team and our guest speaker, Gene Albert, thank you for joining us. We will be providing you with a streaming video version, a downloadable PDF, as well as an MP3 podcast. If you want updates about future Lexbe webinars, please email us at webinars@lexbe.com or follow us on LinkedIn. And please take a moment to complete the short survey that's about to pop up. Your feedback helps us make each session better. And until next time, stay sharp, strategic, and have a great weekend.